Ready? 5 seconds to go. Start. This section applies to any offense triable exclusively by the Court of Sessions or by the court of a special judge appointed under the Criminal Law Amendment Act 1952, 46 of 1952. Any offense punishable with imprisonment which may extend to 7 years or with a more severe sentence. Every magistrate who tenders a pardon under subsection within bracket 1 shall record his reasons for so doing, whether the tender was or was not accepted by the person to whom it was made, and shall, on application made by the accused, furnish him with a copy of such record free of cost. Every person accepting a tender of pardon made under subsection 1 shall be examined as a witness in the court of the magistrate, taking cognizable and cognizance of the offence, and in the subsequent trial, if any shall, unless he is already on bail, be detained in custody until the termination of the trial. Where a person has accepted a tender of pardon made under subsection within bracket 1 and has been examined under subsection within bracket 4, the magistrate, taking cognizance of the offence, shall, without making any future inquiry in the case, commit it for trial to the Court of Session if the offence is triable and triable exclusively by that court, or if the magistrate taking cognizance is the chief judicial magistrate to a court of special judge appointed under the Criminal Law Amendment Act 1952, if the offence is triable exclusive by the court. In any other case, make over the case to the chief judicial magistrate, who shall try the case himself. Power to grant pardon enjoined under section 306 CRPC is a substantial power, and the reasons for tendering pardon must be recorded. It is for the prosecution to ask that a particular accused out of several may be granted pardon if I thinks that it is necessary in the interest of successful prosecution of other offenders, or else the conviction of those offenders would not be easy. This court, in the case, recognized the power of the district magistrate to grant pardon at the investigation stage. This court had the occasion to examine the scope of section 337 and 338 of the old Code CRPC 1998, namely the powers of a special court constituted under the Criminal Law Amendment Act 1952. This court held that reading the proviso to section 337 and provisions of section 338 together, the district magistrate is empowered to tender a pardon even after a commitment if the court so directs. It was also held that under section 8 of the Criminal Law Amendment Act 1952, the special judge has also been granted power of tender pardon. The conferment of this power on the special judge is no way deprives the district magistrate of his power to grant a pardon under section 337 of the code. it was held if at the time when the district magistrate tenders the pardon the case was not before the special judge, then there is no legality committed by the district magistrate. Stop.